think about my dream job or switching the current profile, the first thing that comes to my mind is whether my company is providing the 8 golden benefits to me or not. Are you aware of the 8 benefits of a private employee? If not, then this video is for you. Hello everyone, I am Neha from Webtel. In this video, I am talking about the 8 rights for the private employee by the Indian labor laws. It is important to know what kind of facilities and the benefits are approved by the labor laws. So stay tuned, and before starting this video, I request you to subscribe to our YouTube channel Webtel Electrosoft to get regular compliance updates. So let's start with the summary view of these 8 points, and for this I am taking you to my screen.
So let us just go through with the rights for the private employees as per the Indian labor laws, and those benefits are listed on the screen. As you can see up over here, there are the 8 benefits that we have listed. That includes the employment agreement, maternity benefit, provident fund, gratuity, fair salary and bonus for the employees, appropriate working hours and overtime, right to leaves, and the prevention of sexual harassment at the workplace. So we are going to understand every one of them one by one. So the very first thing that we are going to discuss over here is the employment agreement or bond. So all employees are basically entitled to an employment agreement under which the details of the date on which they have to begin working for the company is mentioned. Then the employment agreement is a written document that outlines the terms and conditions of the employment, as well as the employer and employees' rights and responsibilities are also listed. In case of a dispute, the agreement also contains a mechanism for effective dispute resolution. Many of the organizations are using agreements on bonds because it is a legal document. If any employee disobeys the same, the employer can take legal action against them. However, a non-disclosure of confidential information is also required where the company does not want to disclose the information regarding the financial and business details, technical database, or any of the client's information. So it is recommended that at the time of joining or before signing any agreement, employees should read the legal terms thoroughly, like what will be the legal terms and action that will be taken up by the employer in case of any disputes, or in case the employee leaves the employment during the probation period or any time during the employment. What will be the pros and cons for that? So for more details, we are going to share a link for the contract also in the description. The next benefit that is provided to a private employee is the benefit of maternity leaves. So maternity leave is a work sanctioned period of absence that working women can utilize before or after they deliver a child. The Maternity Benefit Act of 1961 lays down the rules and regulations that concerns maternity leave in India. And maternity leave in India is available to women employees in the public and private sectors also. However, the Indian Maternity Benefit Act does not apply to the women who are self-employed or at the workplaces where they have the employees less than 10. So the benefit is listed on the screen, as you can see up over here. 26 weeks are generally provided as the maternity benefit, but 1 additional month is also provided in case of complicated pregnancy, delivery, premature birth, or medical termination. Some other points are also required to be considered for the purpose of maternity benefit if any female employee wants that. So the female employees who are pregnant cannot be discharged or dismissed on account of such absence, and if they are dismissed, the claim can still be made, and it is discretionary right for both the employer and the private employee. Then the contractual employees can also be apply for maternity benefits as per the judgment passed by the Kerala High Court. Employee Provident Fund Organization is the national organization that manages this retirement benefit scheme for all of the salaried employees. Any organization with more than 20 employees is legally required to register with the EPFO, and any employee who wants to opt out of the scheme, they would have to do it at the beginning of their job. It is recommended for the employee that at the time of joining, they should ensure the applicability of EPF and include the value of EPF in their CTC to get the benefit of EPF at the time of retirement. Now, to avail the benefit of EPFO at the retirement, you would have to understand the process to withdraw the PF amount. So the process is listed onto the screen. There are 5 steps involved. In the first step, we have to log into the UAN member portal using the UAN and password. Then in step 2, In the online services tab, we would have to go to the claim button, claim form 31, 19 and 10C. After that, a page will appear wherein the member details, the KYC detail and service details are appearing. We would have to click onto the proceed for online claim button. Once clicked on that button, the website is redirected to the claims section, wherein another details are appearing like PAN number, the mobile number, UAN number, and we have to choose the type of claim over here. If we want to withdraw PF only or if we want to withdraw pension only. So selecting that, we have to fill out the claim form carefully. After that, an OTP will be sent to your registered mobile number, which was already entered into the form. And after that, the process of withdrawal is initiated. When the claim form is successfully submitted, an SMS notification is also sent to the registered mobile number. Now, once the claim is processed, the amount will be transferred to the employee's bank account. At the time of filing of online withdrawal claim, two options are available over there. Only PF withdrawal, that is form 19, and only pension withdrawal, that means the form 10C. Composite claim form is also there when you are going to apply for the withdrawal offline. So in that case, you are required to fill out the composite claim form, which serves the purpose of three different forms. First one is the form 19 for final PF settlement. Second one is the form 10C for pension withdrawal, and the last one is the form 31 for part withdrawal of PF amount. So the next one is the gratuity. The Payment of Gratuity Act 1972 provides a statutory right to an employee in service for more than 5 years to gratuity. Gratuity is paid as 15 days of salary for every year of service for any employee in that organization. It is one of the retirement benefits given to the employee, and it is a lump sum amount payment made in a gesture of gratitude towards the employee for their service. The amount of gratuity increases with increment and number of years in the services. So if the employee is dismissed for proven lawless or disorderly conduct, forfeits this right upon dismissal. The next option we have over here is the fair salary and the bonus for the employees. So as you can see up over here, Article 39D of the Constitution provides the equal pay for equal work. So the whole point of providing service for an employee is fair and appropriate remuneration. The laws under the Equal Remuneration Act, the Payment of Wages Act mandates timely and fair remuneration of an employee. If an employee is not receiving his or her remuneration as per the employment agreement, can approach the Labour Commissioner or file a civil suit for arrears in the salary. An employee cannot be given wages less than the legal minimum wages as per the law. Getting to our next benefit, that is the payment of bonus. So irrespective of the loss or profits to an organization, it must pay the bonus to its employees whose salary is up to 21,000 rupees, according to the procedure envisaged in the Payment of Bonus Act 1965. The eligibility says that any employee who draws salary or wages up to rupees 21,000 is having the right to claim the bonus. And the purpose of calculation of bonus, according to the 2015 amendment, rupees 7,000 is considered as the ceiling amount, or you can say the maximum limit as wage or salary for the calculation of bonus. And the percentage of bonus is defined as the 8.33% minimum that can range up to 20% maximum of salary or wage. So the next option for appropriate working hours and overtime, the Factory Act provides, and the Shop and Establishment Acts state-wise protects the rights of the workers and the non-workmen. So as you can see up over here, the right available is that all of the employees have a right to work in a safe workplace with basic amenities and hygiene. Any adult worker shall work over 9 hours per day or 48 hours per week, and overtime shall be double the regular wages. For female worker, the work can be from 6 a.m. to 7 p.m. This can be relaxed to 9:30 p.m. upon explicit permission and the payment of overtime and safe transportation facility. Apart from this weekly holiday, half an hour break and no more than 12 hours of work on any given day is mandated. The working hours for child workers are limited to 4.5 hours a day. Now, the next one is the right to leaves. Every employee has the right to paid public leaves and public holidays, such as casual leave, sick leave, privilege leave, or any other kind of leave. For every 240 days of work, an employee is entitled to 12 days of annual leave. An adult worker may avail one earned leave every 20 days, whereas it's 15 days for a young worker. During the notice period of an employee, the employee can take leaves for emergencies, provided the employment agreement does not bar it. The next one is the Prevention of Sexual Harassment at the Workplace. So as you can see up over the screen, Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013 protects women at the workplace from sexual harassment. The Indian Penal Code also provides a penalty of up to 3 years imprisonment with or without fine for sexual harassment. According to Section 2N of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act includes that any or more of the following unwelcome acts or behavior, whether directly or by implication, such as physical contact and advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal or non-verbal conduct of sexual nature. Any employee's legal rights have been thoroughly outlined till now. Every employee has some basic rights and responsibilities in their work. Knowing these employees' rights can help to establish a warm and comfortable work environment. Multiple provisions have been included in Indian employment laws to protect the rights or interests of the employees, some of which are the rights to privacy, fair compensation, paid time off, financial benefits and other rights.
I hope you have understood that it is not sufficient that every month we receive a good amount in our account. A support system in terms of leaves, gratuity, PF funds are also required to grow and improvise the lifestyle. So share this video with your friends and relatives who are working in a private sector and are not aware of the basic employee benefits. If you find this video helpful, then visit the link mentioned in the description below and let us know in the comment section. Also, you can comment if you have any doubts. Give a thumbs up and subscribe to our YouTube channel. Next Tuesday, we will be coming up with another interesting video to improve compliances for you. Till then, stay safe and stay tuned with us for better compliance journey.